Okay. I would call Mr. John Boren to testify.
Witness sworn.
Please state and spell your name.
John D. Boren. Boren is Boren.
What do you do?
I'm an attorney.
And how long have you done that?
In October, it will be 47 years.
So you were admitted in October of 1977?
That is correct.
Where'd you go to law school?
I went to law school in Oklahoma for the first year and then I transferred back to Indiana, which was a lot cheaper as a resident, and I went to McKinney.
What was your practice after admission?
Initially, after being admitted, I was a deputy prosecutor for G. Thomas Gray down in Morgan County for approximately 14 months. At the end of the 14 months, January 1st, of 1979, I opened a practice in a little office above Foley, and Peden in downtown Martinsville, and I practiced there for 2 years. After those 2 years, Steve Oliver and I formed a partnership called Boren, Oliver, and, no, it was just Boren and Oliver initially.
Have you tried both court trials and jury trials?
I have.
How many, approximately, jury trials?
Approximately 100 jury trials and too many court trials, I couldn't count them.
And have you done trial preparation in regard to those trials?
I have done trial preparation. Actually, I started trying jury trials when I was an intern. Back then, it was pretty loose and, as my senior year or last year of law school, I tried 2 jury trials, one was a kidnap and the other one was a major felony case. So I've been doing jury prep ever since I started, and when I went out into private practice, I paid for myself to go down to the National College of Criminal Defense Lawyers and I met, as I now know, people don't recognize these names, but they were icons at the time, Bobby Lee Cook from Valdosta, Georgia, our Ace Horse Haynes from Texas, and Garvin Isaacs, who was from Oklahoma, and they taught us a lot about jury prep.
And with regard to consulting with other attorneys, is that normal and expected?
It is. I, obviously, still do it today. I think maybe I should tell you that I'm of counsel of the law firm Boren, Oliver, and Coffey now, so I've got one foot out the door, trying to clean up all my cases and get out, but...
And how about consulting with non-lawyers?
I think it's more important to consult with non-lawyers than with lawyers, although, obviously, lawyers can give you some tips in regards to the law, but I've only, in 47 years of trying jury trials, I've only had one jury trial in which I had a lawyer on the jury, so it's real important, in my opinion, to consult with non-lawyers.
And in doing that so you get a better perspective of how your jury will react to the evidence.
Absolutely.
So in doing that, do you share with them the discovery and what you've learned and what you expect the evidence to be?
Absolutely. One of the things that I really felt like I had a good handle on was doing what we call mock juries, and for probably about 4 or 5 years, myself and Nina Miller, as a part of the public defender group in Indianapolis, conducted the seminars, and Nina was a psychologist and we taught prospective litigants how to assemble juries, how to interview jurors afterwards, and the evidence that you have. You want to see what's gonna suck the air out of a room or what's gonna be benign. Some things that we, as lawyers, think are real important, mock jurors will tell you they're not important at all.
And then, the consultation with both lawyers and non-lawyers, is that something criminal defense lawyers refer to as brainstorming?
Absolutely. And there's probably another element to brainstorming.
Have you attended continuing legal education seminars where brainstorming was discussed, recommended, and taught?
Yes. I have been a presenter at least 3 different occasions in which we round-tabled, and this was for medical malpractice. I did about a 50-50 practice in my 47 years, 50% was civil, 50% was criminal. But one of the seminars that we did was very much a brainstorming, and we would have a group of people who were attending our seminars and we would do our brainstorming and talk about it.
And then, Are you familiar with the term war room in terms of trial preparation by criminal defense lawyers?
Absolutely.
Please tell the judge what that is.
Well, that's where critiquing your case that you present to, whether it be lay personnel or whether it be attorneys, you get an idea of how your presentation is coming across. And people, hopefully you have good people that will tell you the truth like, this is working and this is not.
But with regard to trial preparation for a major trial, would you have all of the evidence set out in a particular area as you approached trial?
Absolutely. We, in my practice, which is in Martinsville, Indiana, we have 2 conference rooms, and we had a big conference room that, frequently, we would have pieces of evidence such as photographs, diagrams, and as technology began to increase, we would have, cell phone analysis.
And have you ever sent an accidentally misdirected email?
I have both sent accidentally, and I'm not real computer literate, and I've received email that was not intended for me and sent to someone that was not intended.
What would you do once you realized you sent it to the wrong person?
Once I sent it to the wrong person, I would try to communicate to that person that it wasn't intended for them and would they, please, delete it, and depending on the magnitude of whatever I'd sent, I might ask them, don't disclose this to anybody.
And if you received a misdirected email, what would you do?
When I realized it was misdirected, I would stop immediately, call the person, delete the email, and tell the person that sent it to me that I had deleted it.
Having taken such corrective actions with either one, would it cross your mind or would you feel obliged to report that to a prosecutor or a judge?
I guess it would depend upon what it was, I would probably, I don't know that I don't know why I would, report that to either a prosecutor or a judge.
You would figure it was cured, correct?
Right.
Okay. Why are you here?
Well, I'm here because I'm getting old and I have experience and I do have.
Thank you. Nothing further.
Mr. McClelland.
Thank you, Judge. Mr. Boren, good afternoon.
Good afternoon.
In your vast experience, which I appreciate, have you ever been subject to a gag order put down from a court?
I have not been subject to a gag order in my 47 years. And I handled the Stephen Judy case, that was before you were born, I'm quite sure.
Sure.
He and I didn't get along well, so I was relieved that I didn't continue that representation, but I have never received a gag order. In civil practice, I've received non-disclosure.
Sure.
Non-disclosure forms that we filled out.
Are you familiar with the gag order in this case? Have you read over it?
I think I have. My knowledge about this case is probably narrow. I'm sure many people sitting in the gallery know more about the case than I have, but I do believe I've read. Was that gag order in February of 2022, maybe?
No, this was on December 2nd of 2022.
I think I've read that one, as well.
If I were to present to you that the gag order prevented parties from disseminating information to the public, that would coincide with your knowledge of gag orders. Is that a fair statement?
Right. The gag order can be tailored in whatever way the judge chooses to tailor it.
And if you had a gag order that were in place and you were to consult with a civilian, what precaution would you take to ensure that that civilian doesn't disseminate information to the public?
I might make a major mistake and think that my civilian would not disclose anything like that. I think that that would probably be my nature. I've never had an onerous gag order. That's probably the best way I can answer your question.
Have you been subject to, and I think you've answered this, have you been subject to a protective order in terms of discovery in a case?
Protective orders in civil cases, yes, I have. I've never been, let's put it this way, I'm an old man and my memory is not that great, but for over 47 years I don't remember ever receiving anything like that. And even though Morton County's kind of a small place, but we've had some pretty notorious cases and I've handled most of them.
The protective orders that you've had in civil cases, have you ever violated those?
No, I've never I've had one violated that impacted our case, but
Sure.
not me.
If you had a protective order and you did violate it, would you feel obligated?
Certainly, if I realized I had violated it, yeah, I would tell the court.
What precautions, when you've had a protective order for discovery, what precautions do you put in place to ensure that civilian consultants that you have don't disseminate that information that's protected?
I've never had the occasion where I had to sit down and tell. Most of my consultants were experts who were professionals in their field, and I never had a reason to do that. Maybe that's negligent on my part, but I've never had to do that.
When you speak of the war room, would you put any precautions in place to keep the public from entering that war room?
Interestingly enough, I consulted with my partner, Mr. Oliver, and like I said, he's been practicing 45 years, and we never put a lock on any door, we never, put a sign up, it just never was something that crossed my mind.
Have you ever been involved in a murder CSE where there were crime scene photos?
Oh, yes.
And have you ever released those photos to the public?
No. In the Stephen Judy case, I remember Tom Gray handing me, "Here's your copy of these horrific crime scene photographs," and I do remember I shared them with a lady next. I was practicing, I was right out of the prosecutor's office, and I remember showing them to the lady next door and asking her what her impressions were.
Did you ever show those crime scene photos to one of your friends who?
Yes, I'm sure I did, yes.
Okay. And your testimony is that you wouldn't put any safety precautions in place to ensure that those photos didn't get disseminated to the public if you were to show them to a non-lawyer consultant?
Well, now, are you assuming that there's an order telling me that I have to do that or I've got to take precautions?
Sure, let's assume you're bound by a protective order. Is there anything you LD put in place to protect those pictures from being leaked or disseminated to the public?
Objection, Judge. Mr. Boren asked for clarification if there was an order to secure his war room, so then Mr. McClellan switched that around to whether there's a protective order, so it's an assumption, it's not. The question whether the court ordered that war rooms be secure is an assumption that's not in this case, because there was no such order.
Sustained.
Have you ever lied to the court?
Have I?
Yes.
Certainly not knowingly. No, I've never lied.
Sure.
Because the definition of lie is that you
Sure.
lie.
You have a professional liability as an officer of the court to be honest with.
That, yeah. I have a real aversion to the Disciplinary Commission.
I agree. Have you ever told the court one thing and then done the complete opposite?
I certainly don't recall ever doing that.
Okay.
I would say I'm certainly capable of forgetting things, and my staff tells me.
Sure.
I'm even worse now than before.
Sure, understand. Thank you, Mr. Boren. I have no other questions, Judge.
Mr. Hennessy.
No redirect. Thank you.
All right. Thank you, sir. You may step down.